Moving along. Okay, so this is just highlighting what I just said. Further acts of family abuse, committing a criminal offense, prohibiting contact. Those are the types of things that would be a pro-arrest measure. All right, and that would be the same for both family abuse protective orders as well as non-family abuse. All right, so I'm skipping through all these violation penalties to talk about a couple of other things that happened in 2011. Okay, so I think this is one that folks may not know about, some of you may, but the most commonly issued type of protective order is what, do you think? Among the following: emergency, preliminary, and a 2-year protective order. What's the most commonly issued one?
Emergency.
Emergencies, right. So those are ones that law enforcement can get if there's probable cause for assault and battery against a family or household member, or probable cause for an assault. Or the victim can get that herself, the emergency protective order. So often for those EPOs, what happens is it's hard for law enforcement to actually serve them during the time that they're active. They're only active for 3 days. So this provision that happened, this change that happened in 2011, there is a generic form that law enforcement officers have now that they can use as a proxy for serving the emergency protective order. So how that would work is, let's say a law enforcement officer, there's a traffic violation and the law enforcement officer pulls that person over. They go back in their car and they check the person's license and they realize, oh, I can see that there's an outstanding emergency protective order on this guy that I pulled over for a traffic infraction. I can use this form, because I'm far from the courthouse, I can't get the actual emergency protective order, and no one can bring it to me. I can use this form, provisions of the protective order, the emergency, on this generic form, serve it on this respondent, and that is good service of an emergency protective order. It's on the respondent. It's the respondent's responsibility to go and get the actual emergency protective order, but that is considered good service of an emergency protective order.
You're kidding.
No, I'm not
I did
kidding.
know that.
Yeah, see, this is what I'm saying, like these things that people, these nuances that you wouldn't necessarily know because it might not, you know, you're in the Commonwealth's Attorney's Office, you might not know of these practices and tools that are available to other, you know, brother-sister agencies. So I'm not sure how often that's happening in this area, but I could see how helpful it can be for law enforcement for safety purposes, and especially in places where you were talking about remote areas and being far from courthouses, that kind of thing. All right, so this is just a clarification bill, really, that circuit courts, I guess there were some circuit courts that didn't realize they could modify, extend, or dissolve their own protective orders. So apparently now that was clarified in the 2011, some of these changes, that they could indeed modify, dissolve, or extend their own protective orders. I think this is a very helpful thing to think about because it's about minors who are either petitioners or respondents in a protective order. So, as we talked about a little bit earlier, JNDR court is geared to family relationships. So if there is a minor respondent in a protective order, and we're not talking about a family abuse protective order, let's say it's 2 teens, so they're in school together, and they don't have a child together, they don't live together, they don't meet the family or household member relationship. So they would, if the one victim teen needs to get a protective order, she would need to go to general district court. But what's not in general district court that's available in JNDR court to help petitioners file and pull together documentation?
The juvenile judge would be more familiar with working with juveniles and then maybe
Well-
potentially a guardian.
Well, well, you could get a guardian elsewhere in other courts, but that is a good point, that juvenile judges are more familiar with family dynamics. But the other big thing is that there's no court services unit, right? JNDR has a court services unit. Those intake people help the petitioners fill out the paperwork, the petition for the protective order, the affidavit, all that stuff, and then they facilitate the person asking for that protective order from a JNDR court judge. The general district court does not have anything like that. Court services unit is run by a totally different agency than the courts. It's the Department of Juvenile Justice, and so they don't have one. There is no intake unit in the general district court. So what happens with these two teens? I mean, you're talking about teens, it's a family type of relationship, intimate partner. What should happen as of these changes, and this is on your, let me see what slide this is. It starts on slide 31. So what is supposed to happen is that if there is a minor, respondent or petitioner, those folks are, whether they have the family or household member relationship or not, they are to be heard in JNDR court. And so it's the court services unit who would be helping that petitioner with the paperwork, or a parent on behalf of that petitioner with that paperwork and facilitating it. So what's interesting is that the protective order would be a non-family protective order potentially, but it's heard and, adjudicated by a JNDR judge. Okay, so if either the petitioner or the respondent is a minor.
Is this your thing to represent?
Yes, please do.
I didn't put this in to my slides, but I actually have the numbers for this. Because
Good.
it's an interesting statistic. In 2012, there were 267 protective orders issued where either the petitioner or the respondent were a juvenile. And thus far, for the first 6 months of 2013, there have been 245 protective orders issued. Now, I have to preface this with, oh yes, the Office of the Executive Secretary, which collects all this data on protective orders, they do not distinguish between preliminary and permanent protective orders, so I don't know the breakdown between the two, but so far, for the first 6 months, we've had 245 protective orders issued, where a juvenile was either the respondent and/or the petitioner. Just to give you an idea of the prevalence, and that is all in JNDRs.
Mm-hmm.
We've sometimes run into the issue that, and this may have been before 2011, but they say that only DSS can get protective orders for juveniles.
No,
And so we've
those are
fought
gonna
this
be
a lot.
Yeah, that's just not true. I mean, it's just not true. Those are like the temporary restraining order, child protective order type of thing that DSS would be involved with. But in this situation, say my teenage daughter needed to get a protective order against someone, her ex-boyfriend at school, that type of protective order is something that either she or a next friend, me, or someone else deemed a next friend that could be an appropriate adult or guardian can ask for it for her. And then it's up to the different jurisdictions on how they're going to deal with it. Are they going to appoint a guardian ad litem for the minor respondent, etc., if he doesn't have an attorney, that kind of thing. But that's not true. Anyone can ask for a civil protective order regardless of their age.
Are you seeing any parallels between bullying and these protective orders?
Yeah, I mean, I've been hearing about that. No, I tend to get more calls specifically about domestic and sexual violence. I've been hearing talk about that generally, in the community. But that actually brings up a good point that I want to mention and kind of use as sort of a theme to think about when thinking about protective orders. protective orders are not the best option for every situation, right? They can actually escalate violence in certain cases. So that's why if I'm advising a client, or usually when people are getting advice from a local domestic or sexual violence program or working with you all, you have to consider, is this something that is actually gonna help you, or is it gonna make it worse? Because sometimes getting a protective order, even asking for one and serving the respondent and all of that, that can lead to, you're defying that person in court. You're asking official professionals to come into your business and address it, and that can actually endanger victims more. So I always try to help victims figure out and counsel them about whether it's going to be helpful. So in the bullying situation, it's going to really depend on the circumstances. Is the person who's doing the bullying the kind of person who's going to be respectful of a protective order, or is that going to make the bullying worse in terms of practically speaking? But yeah, it could be used for that, as long as the person's able to show an act of violence, force, or threat resulting in bodily injury, or threat of bodily injury, sexual assault, or death happen, then as long as the judge agrees with you and thinks you've met your burden by a preponderance of the evidence, you get your protective order.
Can I go back to my question?
Yes.
And I think one of our main issues comes from the magistrates and issuing EPOs.
Right.
And this talks about the petition, so can the magistrate issue a protective order for a juvenile without DSS? And most of the situations are a child and a sexual assault with a non-family member. And, parents come to us wanting a protective order and want to know why the magistrate would issue it. I talk to the magistrate and they say DSS has got to get it.
Well, that came up recently in the past couple of years, and there was an AG's opinion about it. So, because even though the magistrates and the judges are all part of the court system, the magistrates are seen as a different type of process that teenagers can access directly. Minors can access directly. They don't need to get a next friend to ask for an emergency protective order, or law enforcement can just get it for them. But the problem arises if they want to go further than that 3-day protective order, the emergency protective order. They would then, depending on your jurisdiction, either have to get a parent or a next friend. Some jurisdictions allow minors to petition on their own in JNDR court or general district.
So the magistrate can issue it?
Yes.
For the
Do they know
EPO ones.
Yes. Yes. Clearly. And then I can get you the AG's opinion about the difference between a minor trying to get a protective order from
What's
a
law
magistrate
enforcement?
versus
I mean, it's a
judge.
felony sexual assault, and law enforcement asking for it, and the magistrate saying, no, I can't give it to you.
Yeah, well. I'm just the messenger.
Well, I just want to pull something out and show it to them next time.
Well, after this is over, or, if you have to leave, give me your info and I'll get you the statutes and some of that, the Attorney General's
And the
opinion.
opinions, if I remember correctly, I'm trying to visualize our website, I believe the opinions are listed on our
Yeah, they
website.
are listed on the AG's website. It's just, sometimes it can be hard to find if you don't know what date.
Yes.
What date it was, but.
Yeah, so it is by year, so
Yeah,
it's-
but I'll find it for you and send it to you, and that might be helpful. Sometimes that can be helpful. But yes, it was very clear that teenagers themselves, minors themselves, without anyone, can go directly to the magistrate. So if a law enforcement officer is asking for something for a minor, they can certainly get it without DSS involvement.
And that's not a situation where court services unit would be helpful? Was that something totally different you were talking about earlier?
That's for preliminary protective orders or
Okay.
judicial processes, not the emergent. So the emergency protective order, you ask for it from a magistrate. The preliminary, which is the 15-day or the 2-year protective order, that's through JNDR or General District Court from a judge, not a magistrate. But good point. I'm learning so much when I come out to do trainings. Okay, this is this next slide, your 34, is let me see, this is more about petitioners. All right, let me keep going here. Actually, Melissa, would you be able to help me? Can you come over here and click until you get to this slide while I go over it? So this is about venue, it's slide 34. After the 2011 changes, the venue where you can ask for a protective order is where either party lives, where they have a residence, either petitioner or respondent has a residence, where the act of violence happened, or where there is an active protective order. So that's whether you're seeking a juvenile JNDR, family abuse protective order, or general district court protective order. I think this next slide, 35, this is a change that happened this past year, this past session, 2013. So, just as a clarification and background for this change, when there is a conviction of a violation of a protective order, a new 2-year protective order is issued, okay? So what if the defendant then appeals that, okay, appeals the conviction? What happens, and let's say it's toward the end of the original protective order, so when they appeal the conviction, what happens to that new 2-year protective order, right? Do you all know what happens here, or what has happened in this area? Okay, so there was a question about, is that new 2-year protective order in place? Is that in place during the pendency of the appeal until the conviction is either overturned or affirmed? So that was clarified that the protective order remains in place until the conviction is either affirmed or dismissed. And I think that's especially helpful for victims where the original 2-year protective order has now expired by the time the hearing comes around for the appeal of that violation conviction. So, because otherwise they could potentially have no protection whatsoever, and the original incident maybe happened a couple of years ago. The more recent incident that was based on the underlying violation that led to the conviction might not be enough on its own to get a new 2-year protective order. Make sense to people? All right, and that's for both family abuse and general district court protective orders, non-family protective orders. All right, this is another, I think, interesting change, and this was a long time coming. So this is about electronic tracking devices. So we all have electronic tracking devices probably on our person in our smartphones, right? So there was a lot of study, et cetera, about how to regulate, who can use electronic tracking devices and what happens if someone's using them for illegal purposes, stalking purposes. So that's what this bill is about, now law as of July 1st. So this is on your slide 36. Any person who installs an electronic tracking device through intentionally deceptive means and without consent is guilty of a class 3 misdemeanor. So there are many exceptions to that, right? Like law enforcement, parents or legal guardians of children, minors, representatives of incapacitated adults, owners of fleet vehicles, so I should be able to track my own cars if if my employees are using them, and then private investigators who are using tracking devices in the normal course of business. Except there's a big carve-out about private investigators. So that is that if the private investigator knows that the client is subject to a protective order, so the person who hired them to do the tracking, to follow someone, the private investigator knows the client is subject to a protective order, and they talk about all protective orders, emergencies, preliminaries, 2 years, and even the 20-103, the 15-day protective order you can get through a divorce. If the private investigator knows about that, they are not gonna be covered under this exception. So, just as information for you all, during the testimony about this bill, and it took a couple of years to pass, a lot of private investigators and the associations would show up saying, well, this is our, livelihood, blah, blah, blah. And I think the language here, it's general, there's some wiggle room and it's somewhat vague, but it's a private investigator. I'm thinking of all people who are responsible for doing due diligence. They would be able to check and determine and be responsible for that check to see if the person is subject to a protective order.
But where is the language saying that they have to do the check?
Right here. However, the exception does not apply if the private investigator knows the client is subject, so knows. That's what I'm saying, this vague language.
Yeah, that's the vague language.
So how do you prove that? I would say, you're right, it's vague, but how, a private investigator, it seems to me, would be held to a higher standard of knowing.
And they should have written that into the law.
Well, they're not going to, because that would be too specific, and then that could cause more problems. I mean, that's just, I could see how legislation would never have something that specific, because what happens is when it is that specific, there's always some unintentional consequence that you then have to change the next year. So this is a way for private investigators to be held to the same standards as everybody else. I would think they'd be held to a higher standard. That's my thinking, but we'll see how it, how it plays out in reality. There is nothing that says, and this is how you check, and this is what you must do, step by step.
It seems like they could just say they've gotta make reasonable inquiry or
Exactly.
something.
It seems to me, a private investigator, right? Right.
If they
But
can
it says
find all the
knows.
dirt on someone, it shouldn't be very hard for them to find a court document.
Right. It's not Sushila knowing, it's a private investigator knowing. Anyway, so we'll see how that plays out. All right, so I think that is it for my portion of this, and I can put these slides to Melissa's section. And what's up on the screen now are some of the stats that Melissa's gonna talk about, and they're in the folder that I passed out. So it should look like this, protective orders issued 2012. Where do you wanna be?
It doesn't matter?
Okay.
Just don't want to bump into you. So we thought, it's always interesting to learn the numbers for the protective orders issued and arrest violations, the arrest for them. That data is not provided often enough, and I actually just received this data in the past month, and the arrest data a few weeks ago, regarding protective orders, so we thought we would share them with you at this point. As you mentioned before, somebody said that the EPOs were probably the most prevalent protective orders issued. In 2012, 51,019 emergency protective orders were issued by magistrates throughout the Commonwealth of Virginia. That is up from the year before by, not quite 7,000, but just shy of 7,000 above what it was in 2011. The non-family abuse orders, 13,974 were issued last year. Family abuse orders, 37,045 EPOs. As I mentioned before, we cannot determine, the Office of the Executive Secretary does not distinguish between preliminary protective orders and permanent protective orders. So the numbers that are provided combine both of them. And a total of 15,127 orders were issued between both courts, JDR and GDC. So 12,591 family abuse orders and 2,536 non-family abuse orders were granted. I also wanted to show you the number of petitions filed for the preliminary and permanent. Again, don't know how many went further on or anything like that, but just to show you. So 20,763 petitions were filed, 15,000 were granted. And the breakdown, as you can see, is 15,658 filed, 12,591 issued for family abuse, and 5,105 filed, and just over 2,500 issued, granted, in the court systems throughout the state. So it's an interesting number. I don't have much more to explain about that because I just get the numbers, but it's just something to keep in mind in there. But that's what it is. Move on next.
Yeah.
You have the clicker.
Let me ask you a question about this though. So when you said that the courts don't distinguish between preliminary and permanent, could you have in these stats the preliminary and the permanent for the same people?
Yes.
Okay.
Yes. There's just, I don't know the
Right.
reasons why, but the Office of the Executive Secretary, whether it's the JDR and GDC courts, the systems that report to the OES don't distinguish, or they just all get dumped into one batch, I don't know.
Mm-hmm.
So this could be, in essence, half the number that
It
you're
could be.
showing.
It
Because
could be,
It could
right.
be a temporary order made permanent.
Yeah, that's what we don't know. We don't know of these orders, of the petitions filed and orders granted for temporary orders, we don't know how many moved on to be permanent 2-year orders.
Why can't you do VCC codes like we have to do?
I am not with the Office of the Executive
No, we're
Secretary. I just compile
We're
the
not.
data, and that's what I do. I actually compile all of the statewide data that's provided to me, so Sheila can account for that. We do publish it in an annual report that is published on our website. The one we're doing this year, the 2013, will not go up on the website till January. It's due to the General Assembly January or December 31st. Once it gets to them, then I will put it up. But all of this information is in there. It's much more detailed. There's all these charts that are in there as well.
But aren't you providing ammunition for people who are against the issuing of all these protective orders to say that the system is being abused when in essence it could just be?
I'm not saying it's being
I hear what
abused.
you're saying.
I know what you're saying, though.
Can I just interject and say that a lot of our state agencies have very antiquated systems. It was only, 2009, I believe, that courts were responsible for entering the protective order data into the interface that feeds VESIN. By the end of the day, that only happened in 2009. So, for example, before that was happening on a regular basis, and it had to happen, it was legislature that made that happen. It wasn't the court saying, oh, by the way, we have thousands of protective orders that have not been entered into the systems that law enforcement can actually see, verify, serve, enforce, etc. Some weeks later. That was actually one of our JEEP grants, a prior JEEP grant. That was a big focus of it, to improve service and enforcement. So that's where this legislation, honestly, that was like the beginning of how this legislation came about, that courts must enter and transfer essential data, identifying data about protective orders by the end of the court business day. I mean, that was a huge improvement, and we totally hear what you're saying, that you're right, it can be abused by people who think that this is a frivolous type of procedure, that people abuse it, etc. It's probably half, maybe less, because we all know that if someone seeks a preliminary protective order, there are many that never show up to ask for the full one, right? So
So the data isn't perfect.
right.
It just numbers, and that's why I was sharing them with you, but it is not perfect data. And how OES collected their data has changed in the last couple of years as well. So the numbers last year were a little bit skewed compared to the year before, just because of how they altered how they collect data and the reporting system. So we're starting kind of over with tracking protective orders, and maybe some in the future we'll have how many preliminary orders went on to be 2-year orders. So that would be good information to have. I have unfortunately I don't have it in here, but I can look it up if anybody wants it. I have it with me. The state police provide, the number of protective orders they have in the system at any given day and their service rate, which is pretty high, throughout the state. Because all that gets entered into the VSIN computer. State police keeps all of it, and they do provide me with that information. I do, like I said, I do have it. I didn't put it in here, but I can look it up. That's not an issue if you all want that. But it's, you know, there's tens of thousands of protective orders in the system on any given day. And they have, last year I believe it was about an 84% service rate. I want to say this year was about 90%, but please don't quote me on that. I'd have to actually look up the specific numbers on it. But there's a really good service rate in the state on protective orders, both emergency, preliminary, and 2-year orders. So we're doing a good job. That tracking system's working good. They were able to pull those numbers like that for me when I asked for them, and you know, it's going well. I can say that. It's actually it's going well. They're doing a good job. Going to the next slide.
Keep going.
Just the graph. Yeah. This is just the number of EPOs issued in the last 4 years, just to show you the difference. And that's also the difference in the change of the law from 2011, where that huge jump. And that 2011 data only included 6 months worth of protective orders on the non-family abuse orders, the general district court ones. Because that started July 1, so that data went from July 1 to December 31st. And somewhere in here I had the 2011 ones. Did we pass those?
Yes.
Oh.
Here. This is which one?
You can see this one better. I can see that one. My apologies. It's just a little too far away. So in comparison from what 2011 to 2012, and again, the 2011 reflects this July 1st to December 31st, because that's all we had for data. So this is 2012 is the first full year's worth of data that we have on the general district court protective orders. And no, we don't know how many are intimate partner violence related versus neighbors. There's no way of tracking that at this point. It'd be interesting to know, but there is no way of tracking it. But just to show the comparison between the two, so there's definitely been a jump in protective orders sought and issued since the new law went into effect back in 2011. Keep going? Yes, unless they have questions, it's just comparative data. All right, so arrest, just so you can see how we're doing statewide. For the misdemeanor, these are just misdemeanor arrests. I didn't bring them up, I have the felony information, but looking at it, I didn't put it in. So for the arrests for family abuse, yeah,
That's the violation of family abuse protective order.
thank you, my brain forgot for a second which code section was which. You can see the increase, and we just actually updated our numbers this year to make sure everything, to reflect conviction rates, because those do change from year to year. And for some reason, 2012 is not there. I will get that information for you, but you can see the increase in arrests. I think it's going up steadily.
How
Yes,
do you count the ones that are appealed?
those get reflected in each year. Like I said, this year we were able to show the difference in numbers, because each time they get, if there's a change, it gets reflected. Because all this data goes to the state police. So anytime there's a conviction, all cross, not guilty, dismissal, they all get sent to state police, all that information.
Yes,
And
but
so
if,
when it updates, and they update their system, so when I get new numbers every year, it updates it. So if
but
something
when
changes.
they start out on a misdemeanor violation, and the defendant appeals, if he's convicted, and the circuit court then says he's guilty, how is that reflected in your records?
I
As a
don't-
misdemeanor one coming out of general district court, or is it considered a circuit court order, or what?
That information I do not have. What they give me, and I'm going based off of what they give me, and what we've been reporting on for the past several years, is the section they're convicted under, whether it's a felony or misdemeanor, the number of arrests, the number of guilty verdicts, if there's any juvenile delinquents adjudicated, total number of non-convictions, the total number of not guilties, total number of null pros dismissed, those that have been deemed mentally insane, and if there's any deferred findings.
So they
That's
do
how they're-
report at least the code section that it is, so that you know between felony and misdemeanor.
Right, because this 16.1-253.2 is misdemeanor convictions, violations of family abuse protective orders. The 18.2-60.4 is violations of general district court protective orders. So the felony would have a different statute number. That's how you differentiate those.
Right, and I guess I don't have it. Thought I did. Do I have it here? Aha. That's bad, my paperwork. Not mixed up, it'll be good. All right, so for 2012, the misdemeanor violations, total number of arrests was 3,414. We have that. The total number of guilty findings was 1,322. So again, you can watch the, yes, thank you.
Sure.
I don't know how I missed that.
That's all right.
But, you know, in comparison, so we'll just take last year for those. 1,322 found guilty, 232 found not guilty, 1,172 null pros, and 476 dismissed. There were no deferred or declared mentally insane. For felony arrests, for violations of family abuse orders, 282 arrests, 99 convictions, 5 not guilties, 108 null pros, we don't have that stat. And, I can email it to you, or it'll be in the report. And 40 of them have been dismissed. So that gives you an overall of the whole state. Although, they do send it to me by jurisdiction, so we do, I can't break it down by jurisdiction, but they do send us the information by jurisdiction, so. It is an interesting number. All right, so then I just want, we want to go backwards,
Okay.
just to show you for.
Back one more.
Nope, already there, nope.
Okay.
The violations of the general district court orders. You can see a huge increase.
Yeah.
From 94 in 2010, the law changed in 2011, so we jumped up to 284 in those last 6 months, and there was a good jump. And then for the first year of this, we've had 758 arrests on those. For the first year, that's really good. And then the conviction rate was 235. Yeah, that's pretty good for the first full year of statistics.
Mm-hmm.
And on that, I don't have any difference, it just shows that 55 were found not guilty, 270 were not lost, and 172 were dismissed. So we will keep tracking that, and now that we have the first full year under our belt, we can really start tracking the trends in that and how that's proceeding. And then the next slide is just the graph of the arrests for family abuse protective order violations. That goes all the way back to 97. You can see the steady increase. There was a slight dip, but we're back up again. So you can just see, it's just been an upward trend of arrests. So it gives you an idea of what's going on throughout the Commonwealth as a whole versus your community, but overall the state is pursuing this pretty good. You're welcome.
And that's it for this portion. So I think, do you guys have questions or anything you want to go over? Because I know I was skimming a bunch of things. But hopefully those are all issues that you're well versed in. So do you want to take a break now? Is that what you want to do? And then we can shift gears to a different type of presentation.